Abortion legislation is making news in Ohio, where lawmakers have approved a bill that bans the practice once a fetal heartbeat can be detected as early as 6 weeks after conception. That could make it one of the toughest restrictions in the country if it becomes law. It now heads to the desk of Governor John Kasich. And although Mr. Kasich opposes abortion, in the past he has questioned whether this particular legislation passes constitutional muster. For analysis, we're joined now live by Byron Henry, attorney and constitutional scholar. Morning, Byron. What do you make legally of this so-called heartbeat bill?
Great to be with you, Gordon. Well, specifically, this would be one of the most restrictive abortion laws in the country, mainly because it really tests the Roe v. Wade scheme that's been on the books for over 40 years, 50 years almost, and that is specifically Roe said that the state has no interest in the health of the fetus or protecting the life of the fetus in the first trimester. We know science is advanced, and the trimester scheme is pretty much, from a scientific perspective, out the window, and that was usually the first 13 weeks. So all this is doing is saying now you can basically detect the heartbeat in the first 6 to 8 weeks. And what I think Ohio should argue and is going to argue is that the interest of the state in protecting the fetus doesn't begin at 13 weeks at the end of the first trimester. It begins when you can detect a heartbeat, which is going to back it up a few weeks to 6 to 8 weeks. And so that would be the argument. But under the Supreme Court is currently constituted, even with a President-elect Donald Trump nominee that is conservative and would, let's presume for the moment, that would vote to uphold the regulation like this, you still have Justice Anthony Kennedy on the court, which is the swing vote on abortion cases generally, and he just most recently joined the majority, striking down a host of laws passed in Texas that placed what he believed was an undue burden on a woman's right to have an abortion, and they were basically safety regulations for abortion clinics. So you do have a Supreme Court that seems hostile to what some would consider the most restrictive abortion legislation. Justice Kennedy has been okay with some restrictions on abortion. He hasn't struck all restrictions down, but this may be a bridge too far under the court as currently constituted.
All right, so that said then, Byron, could it be just a matter of time since Mr. Trump obviously might get the chance to pick more than one Supreme Court justice?
Well, basically, I think that's the view of pro-life advocates as well as the legislature in Ohio, and that is as science advances and as the state interest advances in preserving life, and as more and more pro-life legislation is being upheld and being passed across the nation, that you have to take these steps in order to determine, how far the state's interest can go and what the courts will uphold. So you can't just presuppose that a Supreme Court that's never ruled on this particular legislation with potential appointees. I mean, a case like this won't get through the system for a few years. You don't know who's going to be on the Supreme Court. So I think the argument is you can't just presuppose that it's going to be struck down automatically. That's not your job. That's the court's job. Your job is to do the will of the people, to protect the life of the infant. And, of course, John Kasich has been a friend of the pro-life movement because Ohio has a lot of abortion restrictions and some of the most restrictive abortion laws in the country. Of course, this would make it even more restrictive. Yeah,
I know he has said that he's concerned about it passing constitutional muster, but if I understand it correctly from a story I read, I'll read to this line. When the Supreme Court legalized abortion, it said that states could permit restrictions once a fetus was viable. Doesn't that seem to kind of cover this in Ohio?
Well, yes, those fetal heartbeat laws are different than viability. Most states, a lot of states have laws restricting abortion viability. They range from 20 to 24 weeks. Texas has one that is a 20-week statute. It bans abortion except in very limited circumstances after 20 weeks.
I see.
This is before viability. This is not that the fetus is obviously viable at 6 to 8 weeks. Most science, it's almost, that'd be unanimous that they are not viable after 6 to 8 weeks. This is that the state has an interest in preserving the life of the fetus once a heartbeat is detected, meaning it is gone far enough in the line not to be viable, but to merit protection, such as some of the fetal pain laws that you've seen in different states, where once a fetus can feel pain from the process, they may not be viable, so to speak, but they can feel pain. So the state has an interest in protecting the life and health of the fetus when it can feel pain. So that's kind of the difference between viability and moving it even further back, inside 20 weeks to 6 to 8 weeks.
Wow. Fine point for sure. Hey, thanks for a few minutes, Byron. Much appreciated. Byron Henry, attorney and constitutional scholar, talking about this so-called heartbeat bill that has advanced in Ohio. It's 20 minutes now in front of the hour on This Morning, America's First News. Thanks for being with us.